let's talk about commercial transactions. One would think that when we have a commercial transaction, it's pretty clear that there's likely to be intention. But tricky problems can be created when, in fact, commercial people don't want to be bound yet, or don't want to be bound unless, or don't want to be bound to a particular thing. So let's explore how these arise in practice and make sure that we understand what the court looks for in ascertaining whether or not there is intention in relation to commercial contracts. So in a commercial transaction, we start with the rebuttable presumption that they are intended to be legally binding, and on the whole, we don't have any issues. We don't have any real problems with establishing intention to create a legal relation. Couple of areas where this comes up, early in negotiations in particular, and we'll move on to those in a subsequent topic, but in particular with letters of comfort, or honour clauses, or where parties have specifically negated any intention to be bound in relation to the whole of a contract or in relation to a particular element of it. So let's start with this idea of agreements to agree. It's really not at all unusual to see commercial people get together and say, actually, we'll agree all of these terms, but this bit, we need more information or we're not sure yet, so we'll reach an agreement about that in the future. I've seen it arise all the time. Commercial people are always telling me that they want to, get around the table in a year's time when they've got a bit more information. And at that stage, they can work out what the rent will be or what the pricing will be or how quickly they need something delivered. Courts will not enforce an agreement between parties to reach agreement in the future about something. In most cases, it'll be of no consequence whether an agreement is silent in relation to an essential term or provides that the parties will reach an agreement on that term in the future. In neither case, we have a binding contract. And it's very rare that somebody would be trying to indicate that a contract exists. The distinction between, though, this idea of silence on an essential term and agreeing something in the future is an important thing, particularly once we get to the section in the second half of the semester on gap filling and when the courts will actually fill in a gap. The creation of legal relations is a matter of manifested intention. It's clear that the parties can, if they wish, enter into a non-binding commercial agreement. Courts will give effect to an express stipulation that an agreement is not to be legally binding. So it's easy when the document says, draft, not intended to be binding, this is just a statement of our intentions. Sometimes there'll be something a little bit more detailed than that, something which we would refer to as an honour clause. So a provision that either expressly or implicitly provides that an agreement is only binding as a matter of conscience or in honour only. So in the case of Rose and Frank Company and J.R. Crompton Brothers, the House of Lords in the UK recognised the effectiveness of this kind of clause. The clause itself was contained in an agreement made between a manufacturer and a distributor, which gave the distributor the right to sell the manufacturer's product for a stipulated period. The agreement contained an honourable pledge clause, so a clause that provided that the agreement wasn't entered into as a legal agreement and wasn't subject to a legal jurisdiction, but simply recorded the parties' purposes and their intention to which they each honourably pledged themselves. The distributor ultimately sought damages for breach of the contract when the manufacturer didn't meet that honourable pledge, and they did that by terminating the distribution agreement without giving stipulated notice. And the court found that actually there was no intention to create a legal relationship here, that at best this agreement provided a description of what the parties in honourable circumstances would do. really distinguishing the circumstances from a promise that was made that was intended to be enforceable as such. Rather, it was just an honourable intention. Once an agreement is binding, the courts cannot exclude the parties cannot exclude the jurisdiction of the courts. This is for public policy reasons. The very nature of an agreement or a contract at law is that contract or agreement should be enforceable by a court. To actually exclude the ability of the court to be the ultimate arbitrator is against public policy, and the clause itself, or the provision that seeks to do that, will be considered ultra vires, in other words, illegal or outside the law, and will be given no impact or effect. So let's talk about a situation where we see letters of comfort or honour clauses and where the issues arise. So let me give you some background here. It's quite usual for a lender to seek security by way of guarantee or some kind of formal support for money that they advance to somebody else. Particularly you see this when you have parent companies and subsidiaries. So a parent company is the company at the top of the tree, and it has a number of subsidiaries, some of which might be wholly owned, some of which might be partly owned, that have been incorporated for the very purpose of going off and doing their business, taking risks, doing whatever it is that they've been incorporated to do. And so if a subsidiary lends money and it's part of a larger group, often the lender will say, before we actually advance you money for this new venture, we want to know that you're good for it, and that you're going to pay us back. And so just like when I borrowed money from the bank to mortgage my house, I had to provide security for my promise to repay, in that case in the form of giving them a mortgage, which is essentially a set of legal rights over the property itself, which means if I don't pay, they can come in, foreclose, sell the property, blah, blah, blah. So that's essentially what a security is. So, but it's not unusual for parent companies to say, well, no, I'm not prepared to give you any security. One of the reasons that we're doing this risky business and borrowing money from you in this separate entity is we want to have the ability to control the damage if things go wrong. What we will do is provide the right amount of cash support. We'll provide you with information in our bank details, etc. But we don't actually want to provide you with a guarantee. Instead, we'll provide you with a kind of letter that details the financial viability of the subsidiary. And that's the kind of thing that we refer to when we talk about a letter of comfort. The legal effect of a letter of comfort, just as a statement, is really not clear. In each case, it'll depend on the facts and the circumstances. In some instances, letters of comfort are regarded as statements of intention, so they give no more than a moral responsibility or act as nothing more than an honour clause on the part of the bank or the parent company. So let's have a look at a couple of examples. One of the best known cases, and it is in your case book, is the case of Banque Brussels and ANI, a 1989 case. Basically, that took place so the events leading up to it took place just after a period of massive growth in the economy worldwide, followed by quite a big crash. So essentially this diagram here, let me just grab my pen to show you, describes the situation. So this company, ANI, held 45% of a company called Spedley Holdings, and Spedley Holdings in turn owned 100% of a company called Spedley Securities. So basically, Spedley Securities here wanted to borrow money, $5 million, not actually a lot of money in today's terms for this kind of transaction, from Banque Brussels. And Banque Brussels sought some security from ANI. And ANI said, no, but what we will do is we will give you a letter of comfort. So let's have a look at what it said. The letter of comfort had two relevant terms in it. Firstly, it said that it is our practice, so it is ANI's practice, to ensure that our affiliate, Spedley Security, will at all times be in a position to meet its financial obligations as they fall due. Secondly, ANI said that it would give Bank Brussels 90 days notice of any decision to dispose of its interest in Spedley Holdings Limited. Remember, Spedley Holdings is the entity that it holds 45% of, which in turn owns 100% of Spedley Securities. Basically, as it transpired, ANI didn't keep that part of the promise. It sold its shares without giving any notice at all, and Spedley Securities ended up defaulting on the loan. So Bank Brussels sued ANI in contract, and the issue was, what was the legal effect of the letter of comfort? Was it binding and accordingly some kind of guarantee or promise that they would ensure that the affiliate was at all times in a position to meet its financial obligations? Or was it merely just a letter of comfort, an honour clause? The questions are, the court said, and it was Chief Justice Rogers at the time, said that the question was whether, having regard to ANI's letter, there was an intention to create legal relations, and whether the terms of the letter were sufficiently promissory in nature to be contractual. It was held, in relation to the issue of intention, that the starting point is the prima facie presumption that in commercial transactions there's an intention to enter to create a legal relationship, nothing new to us, and that the onus of proving the absence of that intention rests with the party who asserts no legal effect is intended. So in other words, if ANI didn't want to stand behind the letter, it was up to ANI to demonstrate no legal intention was intended, or that it was clear that there was no legal intention or intention to enter into a legal relationship. Ultimately, it was held in that case that if the statements, whether the statements are promissory or not in character, the court should enforce them when they're uttered in the course of a business and there is no clear indication they're not intended to be legally enforceable. The letter that ANI gave included enforceable contractual promises to provide notice of its intention to dispose of Spedley Holdings. And that allowed that, if that notice had been given, that allowed a 90-day period for Bank Brussels to re-satisfy itself about securities' position to repay the bank. And so ultimately it was held that the bank was entitled to damages for ANI's breaches of those promises. So I'd like now to compare the ANI decision with Kleinwort, Benson and MMC, or the Malaysian Mining Corp case, a UK House of Lords decision that was found, very, very similar issues, and the cases are basically in the same year. I think these cases demonstrate how the language used in the document makes such a big impact. So, sorry, I said it was a House of Lords decision. It's actually the English Court of Appeal. So in Kleinwort Benson, the English Court of Appeal held that the presumption that the legal relations are intended only arises when the words used in the relevant document can be treated as contractual promise. So they went to the actual words themselves. Where a statement made in a commercial document doesn't appear to have been intended as a contractual promise, then the onus will lie on the party alleging a contract to show that this statement was intended to be contractually binding. The letter of comfort in this particular case could not be regarded as being intended to contain a contractual promise. So let's look at how they were different. So in this case, there were two letters of comfort that were being given by MMC, the parent company. Let me just use my pointer again, to MMC, the parent company, to the bank, Kleinwort Benson. These supported a £10 million facility that went to MMC Metals, a wholly owned subsidiary. And there was also an agreement in place between MMC and Kleinwort Benson around the financing of the whole group. So in the case, Kleinwort Benson agreed with MMC to make a loan facility to MMC's wholly owned subsidiary, Metals, to support metals trading on the London Metal Exchange. As part of the agreement, MMC gave two letters of comfort, which stated, amongst other things, it is our policy to ensure that the business of metals is at all times in a position to meet its liabilities to you under these loan facility arrangements. Ultimately, the tin market collapsed, and Metals owed Kleinwort Benson the whole of the amount that was available under the facility, so £10 million. And Kleinwort Benson sued MMC, the parent company, for breach of contract. In the first instance, it was held that commercial people intend their agreements to be binding, and so the letter that contained the contractual undertaking was effective to underwrite the subsidiary's indebtedness. However, on appeal, Lord Justice Ralph Gibson held that the letter contained no such contractual undertaking. It was merely a representation of facts, and it referred to their policy. It only carried with it a moral obligation on the part of MMC to meet Metals' debt, and that it had been structured precisely in that way because MMC had no intention to make a binding promise. And if you have a look at the facts of that case, you'll see how that pans out. So next, we're going to talk about family and social relationships, and I'll meet you in that little mini video again.